Hi there. My name is Jeremy Anderson. I'm one of the notaries public at Old House Notary here in Courtenay. Our client-centered practice assists clients with estate planning by drawing wills, powers of attorney, and representation agreements. And we assist our clients with buying, selling, and financing real estate. This will be the first in a series of videos on estate planning. And in this video, I'm going to discuss powers of attorney. Now, it's important to first clarify, in Canada, when we use the word attorney, we are not referring to a lawyer or a solicitor, unlike our neighbors to the south. In Canada, an attorney refers to someone to whom you delegate responsibility to make all kinds of financial and legal decisions for you, with a few exceptions. Now, let's start by talking about who needs a power of attorney. First off, spouses need a power of attorney. Now, it's very common to think when you're in a spousal or marital relationship that you're a unit and you can act on each other's behalves. But that's not necessarily how the law works. So if you're in a spousal or marital or any sort of relationship where you want to act on behalf of someone else or each other, a power of attorney is an important tool to have. Now, on that note, anyone who owns property jointly or any sort of asset jointly would benefit from a power of attorney. So for example, if you are in a spousal relationship and you own your home in joint tenancy with your spouse, we need both signatures on any documents when we are acting on the title. So that could mean if you are selling the property, if you're getting a new mortgage, if you're refinancing a mortgage, in any of those scenarios, we need all of the signatures from all joint tenants. Which of course is not a problem at all if everybody is healthy and well and present. But if one of the joint tenants or more of the joint tenants are incapacitated and are unable to sign documents, the other joint tenants are potentially hamstrung without a power of attorney. Now that's looking at a worst case negative scenario. But perhaps in a more positive scenario, you or your spouse or both of you are traveling and you need someone to sign documents on behalf of you. So for example, maybe you're selling your house and you're traveling somewhere and you need someone back home to sign legal documents for you. Or maybe you're selling another asset like a vehicle that you own jointly and you need someone to sign on your behalf. Now on that note, powers of attorney can be very broad. You can grant your attorney the authority to do almost anything that you can do legally or financially. But that's not necessarily what everybody wants in every scenario. So take that scenario where maybe you're selling your car or maybe you're selling your house and you want somebody to assist you with just that specific transaction. Well, we can draw a power of attorney that allows them to deal specifically with that one particular transaction or asset, or even for a very specific point of time, say while you're traveling abroad. And of course, the last example I've touched on a moment ago, which is incapacity. So of course, the risk is that if you become incapable of signing documents yourself, then you need an attorney to sign on your behalf. Now, the next logical question is, well, of course, who can prepare a power of attorney? Well, legally, anyone can have a power of attorney if they're over the age of 19. Now, in order to prepare a power of attorney, you have to have legal capacity, as we call it. And this is an important threshold. What it essentially means is that you have to know what you're doing when you're preparing the power of attorney. And you need to know what you have at stake. Because the risk, of course, is while you can name someone whom you trust and you intend to do things for you, acting in your best interest, there is always a risk that they may either intentionally or unintentionally mismanage your assets. So you have to have the legal capacity to understand all of that. Now, an important distinction to be made is that the legal capacity threshold is different from any other threshold, such as a medical measurement of capacity. So as part of our process as legal professionals drawing powers of attorney, we'll meet with you and do a bit of an assessment of your legal capacity, which essentially means we have a discussion to ensure that you know exactly what you're doing. Now, once you have a power of attorney, there are certain circumstances under which a power of attorney may become invalid. The primary one, and perhaps the most obvious, is on your death, because that's when your will would take effect. If you revoke your power of attorney, obviously that would also become invalid. And you can potentially put terms in the power of attorney that make it specifically void after a period of time or after an event or transaction has taken place. One of the other examples is if your attorney resigns, because obviously at that point in time, they would no longer be your attorney. Now, this is a very brief overlook of powers of attorney, and this is a very nuanced and detailed and complicated area of law. So it's important to see a legal professional to have a power of attorney drawn up, rather than trying to draw a power of attorney on your own, which can lead to legal deficiencies in terms of the formalities and may make it invalid, or may put you in a position where someone who might be relying on that power of attorney won't accept it. So if you need help with a power of attorney, give us a call. We'd be happy to help.